Well, I think that makes that 2 minutes past six, coming up to 3 minutes past. So I know that time is precious. So we'll start this, go through the beginning parts, and then we'll actually get on with the content, and people join as we go through that. Well, hello everyone, and welcome back. This is our fourth session. Hasn't time gone quickly from that? There's been a question. Thank you. For putting it up on the screen there. Harry is going to revitalise those previous sessions. I'm sure you've had the full of my voice by now, but Harry will generate a new link for that after. So any sessions that you've missed, we'll put up there for that extra learning from there. So today's the fourth Crammer session. Obviously, we're going to cover curriculum that's examined in the NIE, sergeants and inspectors. So whatever exam you're sitting today, it'll hopefully be of benefit to you. Well, you should know by now, but those that have been with us, my name is James and I'm one of the tutors for police revision, and I'll be taking the session today, and I took the previous 3 or 4 sessions, 3 we've had so far. So police revision, as I'm sure you're aware, is one of the leading providers of revision material for police exams. We'll cover a little bit more of the end from that. I think there's also a discount code on the screen. It's 50% off, but it's very short. I think it just covers the NIE for the next week. But anyone wants some last minute revision, please have a look. Right, so let me just go through. So hopefully you can see the screen now. So today's session, we're going to be looking at the topic of sexual offences, and we're going to work through a presentation very similar to how we've done the other ones. We'll look at some exam style questions. You're fantastic. You get all those correct from there. I'm really impressed so far. And we'll look at learning around the topic. So it is a live session. You'll have the opportunity to ask questions as we go along on the chat bar, but we do have a lot to cover. As you'll know from the previous ones, I do like to get as much as we can in there. So if there's any burning questions, if we can cover them at the end, then obviously I'll go through them with you either over Teams, or we can speak to you over email and take it from that. And thank you so many of you got in contact with me and just said, I'm not sure about this, James, I'm not sure about that. My email address at the end, ask me. We're getting close to that exam now, so we really want to make sure that we understand the topic, we understand anything that we're not sure about. You know, we really want to just sort out those, we get all those questions correct and you fly in that exam. So the topic we're going to look at today is sexual offences. Now, these can be some of the most emotive cases that you'll deal with in your career, and most probably have so far, especially when it comes to children. They can also be some of the most rewarding cases, as there's not many better feelings than locking up a sexual predator for many years. A lot of us, why we join the job, to protect from there. Well, crimes of this nature can affect victims and families for their lifetime. So it's really important that we understand what we need to prove to maximise the opportunities of convicting those guilty of such heinous crimes. And you know, it's really important. I said that all through these sessions. Remember that we're learning the crime, we're learning about the crime, the offences, the case law, to make you better detectives, better sergeants, better inspectors, and you'll know that law, and you'll put better cases together, and you'll lock people up that deserve to be locked up. Really, really important. So just a little bit of context before we start going into the content from there. Now, sexual offences usually make up about 15% of the NIE, sometimes more. So about 13 to 14 questions, a few more for the sergeants and inspectors from there. Now, some people say this isn't a huge area, but it's a great area to secure high marks on. And I really stress this, and I have over the years to candidates from there. The reason is the subject isn't huge. I'm going to cover almost all of it today in the hour session from there. The offences are straightforward, and then once we've learned the ages, the small bits of case law associated with it, those little bit of foibles that we'll go through on those offences, you have a really good chance of getting all of these questions right. And let me tell you, if you get all of your sexual offences questions right in the exam, that is an amazing start. That is like 14, 15% of your mark immediately. And that we really can work through that, and we're going to do that today, so you get all of that right. So let's start. Let's build our confidence and kick off with a nice question that you're all going to impress me on. Now, sorry, those that haven't joined us before, please feel free on the chat bar. You pop A, B, C, or D down as per normal. I'll read out the question because some people like to listen to this in the car. My dulcet tones from that. So I'll read out the questions and then put your answer on the chat board if you so wish. If you don't, just answer it at home and then we'll go through the answer. So Rachel is 21 years old and she's approached the police and stated that she was the victim of a sexual assault, section 3, where a male approached her in the park and grabbed her breasts, and that's above clothing. She screamed for help and the offender ran off. Rachel asks PC Hooper, who is taking the initial report, whether her name will be disclosed as she does not want anyone in her family knowing what has happened. Which of the following statements is correct in relation to Rachel's request? Is it A, as Rachel has been a victim of sexual assault by touching, she's not automatically granted anonymity. However, an application can be made to the magistrate's court. B, Rachel will be entitled to anonymity only if a prosecution occurs. Her identity will, however, not be disclosed during the investigation unless an information request is received in relation to the case. If this occurs, then the police can apply for an anonymity order. C, Rachel is not entitled to anonymity as the offence is neither rape or assault by penetration. Or D, Rachel is entitled to anonymity as she has been a victim of sexual assault by touching. Right, let me just move over all of these D's on my other laptop at the moment. Fantastic, absolutely. You work through it. Now, take as long as you need from that. Give your answer. But I see that D is certainly the winner. Well, let's hope that I got it right as well. And that's good news. D, Rachel is entitled to anonymity as she has been the victim of a sexual assault by touching. So anonymity is governed under the Sexual Offences Amendment Act 1992, and section 1 says this: where an allegation has been made that an offence to which this act applies has been committed against a person, no matter relating to that person shall during the person's lifetime be included in any publication if it's likely to lead members of the public to identify that person as the person against whom the offence is alleged to have been committed. So it's lifetime anonymity. And where a person is accused of an offence to which this act applies, no matter likely to lead members of the public to identify a person as the person against whom the offence is alleged to have been committed, the complainant shall during the complainant's lifetime be included in any publication. So this means no reporting specifically on the person's name, the person's address, identity of any school or educational establishment, identity of any place of work, and any still or moving picture of the person. Pretty much anything that can lead to them being identified. And it applies to almost all sexual offences as well as attempts and conspiracies, but it does not apply to sex with an adult relative or sexual activity in a toilet. So is there ever a case where anonymity can be lifted? Well, the answer is yes, and it's governed under section 3 of the Act. This means restrictions can be lifted if publicity is required by the accused so that witnesses will come forward and the conduct of the defence is likely to be seriously prejudiced if the direction is not given, or the trial judge is satisfied that imposition of the prohibition imposes a substantial and unreasonable restriction on the reporting of the proceedings and it's in the public interest to relax the restriction. So that's all about anonymity. You all did fantastically well, as you always do with those questions. But I wanted to start off with that because it's a really good way of understanding sexual offences. It is quite straightforward in there, in that it spells out pretty much what you can and can't do. Now, I said to you only, obviously, it's about the little differences that we need to remember for the exam that comes onto the question. You're very comfortable, you got the answer a D, but we just have to look at that other part from there. What does it apply to all sexual offences? Well, we know the two that it doesn't to, but it does apply to attempts and conspiracies, and there can be a case when the anonymity is lifted. Well, absolutely fantastic. Really well done, everybody. Let's go on to our next section. Right, well, we're going to have a look now at the offence of rape, and we'll also look at sexual assault from there. Now, one area we're going to look at here is consent and some key case law around it that will assist you. So we'll go as we did again. We've done that little opening question. We'll have one more question now about an offence, and then we'll move on to our learning. I think there's about 7 or 8 questions, as per normal in here, as we go along. So Clark has started a relationship with Brenda. They decide to have sex, but Brenda explains to Clark that although she is on a contraception, the pill, she would like Clark to wear a condom. Clark tells Brenda that he finds condom painful and assures her that he will not ejaculate inside her. Brenda refuses, stating that she will only have sex if he wears a condom. Clark accepts this and prior to having sex, puts on a condom. They start having penetrative sex, and halfway through, Clark removes the condom without Brenda's knowledge and continues to have sexual intercourse. At the point of ejaculation, he withdraws and ejaculates into his hand before going straight into the bathroom and flushing the condom down the toilet. Brenda is unaware and believes a condom was used throughout. Does Clark commit the offence of rape in these circumstances? A, no Clark has used a condom at the start of the sexual intercourse and has not ejaculated inside Brenda. Brenda is unaware and therefore the offence is not made out. B, yes, Brenda only consented to sexual intercourse with Clark on the basis he wears a condom throughout. He has not fulfilled his condition. C, no, simply not fulfilling a condition is not sufficient to commit the offence of rape. Brenda is consenting to sexual intercourse with Clark. If Brenda has concerns that Clark will not abide to the conditions, then she should not have had sex with him. And D, yes, any breach of pre-agreed conditions or lies such as pretending to be wealthy when actually not means the offence of rape is made out, as true consent has not been gained. All right, let's see how we're doing here. So lots and lots of B's coming up. I think you're absolutely brilliant, all of you. You really are really well from that. And absolutely correct. The answer is B. Brenda only consented sexual intercourse with Clark on the basis that he wear a condom throughout, and he's not fulfilled this condition. Now, we'll cover conditions shortly, but this question is based on case law, specifically Assange versus the Swedish Prosecution Authority, where consent for sexual intercourse was only granted on the basis that a condom was used. If a condom was not used, then there was no consent. So answer A is incorrect, as the fact Brenda is unaware is irrelevant. C is incorrect, as consent with conditions is recognised, as in this case. And answer D is incorrect, as a lie to someone's wealth or status would not be enough to negate consent. Now, that's something we'll cover a little bit shortly from there when it comes to lying. But I want to go through that in a bit more detail with a few examples. But important to remember for exam, a lie to someone's wealth or status is not enough to negate consent. So this leads us nicely onto the issue of consent. But before I do that, let's just have a closer look at the offence of rape. So the offence of rape is governed under Section 1 of the Sexual Offences Act 2003. A person, here known as A, commits an offence if he intentionally penetrates the vagina, anus or mouth of another person with his penis. B does not consent to the penetration, and A does not reasonably believe that B consents. Whether a belief is reasonable is to be determined having regard to all the circumstances, including any steps A has taken to ascertain whether B consents. So the act is the intentional penetration of the vagina, anus or mouth with a penis, and penetration is considered from entry to withdrawal, and there is no requirement for ejaculation to occur for the offence to be made out. Now, when we speak of parts of the body, we also include parts that have been surgically constructed, meaning that a person with a surgically constructed penis can commit the offence of rape. And likewise, a victim with, for example, a surgically constructed vagina can, of course, become a victim of rape. And the offence wording concludes with A does not reasonably believe that B consents, and whether a belief is reasonable is to be determined about having regard to all of the circumstances, including any steps A has taken as to whether B consents. Now, when it comes to sexual offences, consent is a really big area, and we're going to cover and work through it now. So, the Sexual Offences Act 2003, Section 74. For the purpose of this part, a person consents if they agree by choice and have the freedom and capacity to make that choice. When it comes to the offence of rape, the issue of consent is at the forefront. A person must consent to have sex, and they must have the freedom and capacity to make that choice. Consider this as true consent. I'm going to speak of true consent coming up. So an example of how consent can be negated. So the case of PC Mitchell, which is a very sad case, who was an officer who forced a woman to have sex with him, threatening that that if she didn't, that her children would be taken away. And the victim went on to agree to have sex and did have sex with PC Mitchell. Well, that's not true consent. She had no choice from there. So the actions of PC Mitchell demonstrated that that consent, even if it's given through words from that, is not true consent if it's given with a level of threat. An example there was forcing to take the children away. Now, another term to consider is capacity. Again, we'll cover this shortly from there. Again, which means that true consent can only be given if the person has capacity to give it. I mean, capacity is not defined in law, but we can take a common sense approach to it from there. A 6-year-old, for instance, cannot give true consent, nor perhaps somebody with very severe learning difficulties. Now, cases will be subjective from there, and that perhaps is why capacity hasn't been defined fully, and each case has to be looked. And of course, consent can be withdrawn at any time, and any continued act could amount to a sexual offence. So, for example, Linda consents to have sexual intercourse with Mark, and during the sexual intercourse, Mark makes comments that Linda finds very offensive, and she tells Mark that she no longer wants to have sex with him and for him to stop. If Mark ignores this and continues to have sexual intercourse with Linda, even though it's clear that she no longer consents, then again, he could be committing the offence of rape. So I'd like now to bring to your attention the case of RVB, and this is where the defendant was accused of raping a victim outside of a nightclub. Now, after his arrest, the defendant informed the custody officer that he was HIV positive, but had not told the victim of this prior to them having intercourse. The defendant was convicted of rape. He appealed, and this was on the basis that his HIV status was not relevant to sexual consent. Well, in short, he states the fact that he was HIV positive had no bearing whatsoever on the fact that the victim consented to sexual intercourse. Essentially, it was a separate matter. And the appeal succeeded, and the rape conviction quashed, and a retrial ordered. The Court of Appeal held that the defendant's HIV statement was not relevant to whether a victim had freedom or capacity to consent to a sexual act. The key question in a sexual offences case, whether the victim consented to the sexual act and not whether they consented to the sexual act with an HIV positive person. But this does not mean that the defendant can simply not mention HIV if having sexual relations with someone and escape criminal liability. Rather, that the transmission of HIV during consensual sex with an unwitting victim would amount to an offence of inflicting grievous bodily harm under the Offences Against the Persons Act. This is because the victim would only have consented to sex and not to the risk of transmission of disease if they were unaware of their partner's HIV status. So let's simplify the two scenarios here. Mark has HIV and makes no mention of his condition prior to having sexual intercourse with Linda, and Linda herself does not suspect or ask the question. Well, this may constitute an offence of GBH. The second scenario is where Mark states to Linda or answers the question that she asks as to whether he has HIV or any sexually transmitted diseases, and he lies and says, "No, I do not." Well, this could constitute rape. So for exam purposes, say nothing, GBH. If you lie, potentially it could be rape. So what about the term conditional consent? Well, this is covered under section 74 and deals with a number of scenarios where there was a condition put on sex. Now, going back to our question, we spoke of the removal of the condom that was covered in the case of Assange versus Sweden 2011. Well, that's a good example of conditional consent. In our example, the lady would only have sexual intercourse if a condom was worn. That was changed because it was taken off halfway through sexual intercourse, so that condition has been broken. Well, another case is where a condition was stated that the victim would only have sexual intercourse on the basis that the male party did not ejaculate inside her. And she made this blatantly clear as a condition to have sex. The male party ignored this and deliberately ejaculated inside her, and this was found to qualify as rape. So when you think of it, it's fairly straightforward. There's a condition in place for sex to occur, and the person deliberately negates that condition. Now let's focus on that word there, deliberately. And that's what you've got to consider in the scenario from there. So in that case that we just spoke about, the male party understands that a condition of sex was not to ejaculate inside the female. And what he has done is he has deliberately ejaculated inside of her from that. So that's a deliberate act and therefore could make him liable. Now, things obviously could change if it was accidental from there. But to keep things straight from there in wording, if the word, and the word will be in the exam, deliberately, then of course, he has deliberately broken that condition and could be criminally liable. Well, what about a lie about fertility? Well, this was examined in the case of R versus Lawrence 2020, where Lawrence falsely represented the complainant that he had a vasectomy, and therefore she could not be at risk or extremely low risk of conceiving a child. Based on this, the complainant had unprotected sex with him, agreeing both to the penetration and subsequent ejaculation. She found out that he had lied about his vasectomy, contacted the police, and Lawrence was convicted of rape. This, however, was quashed. It was found that lying about fertility does not negate consent. So some really interesting ones there. Now, the final case we'll look at is the case of McNally versus R, which is a really interesting case where Justin McNally and a girl referred to in court records as M met on an online gaming site. McNally was a Scottish 13-year-old and M was a year younger and living in London. Now, on the site, McNally used a male avatar named Scott, and over 3.5 years, the two developed an internet relationship which became sexual. McNally and M met for the first time in person after her 16th birthday, and that was in March 2011. At that time, McNally presented as a boy, and they met further times and engaged in sexual acts, including suggested penetration with a dildo. Now, the victim found out that she'd been lied to and that McNally was, in fact, female. The victim stated that she was heterosexual and would never have consented if she'd known that McNally was female. So the question was asked whether McNally's deception deprived the victim of a freedom to choose, because to choose to have sexual encounters with a boy and her preference, her freedom to choose whether or not to have a sexual encounter with a girl, and this was removed by the appellant's deception. The appeal failed and the conviction of assault by penetration upheld, outlining that lying about one's gender can negate given consent. So we'll move on now to section 75, which deals with evidential presumptions about consent and applies to offence of rape, assault by penetration, sexual assault, causing sexual activity without consent. Well, in simple terms, if the prosecution can show that one of the above sexual offences occurred and the offender was aware of a condition that existed, then assumptions can be made around consent. So what are the conditions? And this is where I say it's really straightforward. They call it, we have to give these wonderful titles of evidential presumptions about consent. But what I'm about to read out are the conditions for these are violence or the threat of violence was used against them or another person. So, for example, from that, if you threatened to stab someone if they didn't have sex with you, the victim was unlawfully detained at the time of the act, perhaps handcuffing a woman to a bed without her consent, or the victim was asleep or unconscious and therefore unaware of the act, or had been administered a substance causing them to be overpowered like a date rape drug, or owing to a physical disability, they cannot communicate their lack of consent. And it's really, really straightforward stuff. We call it Section 75, evidential presumptions about consent, but it's about basic conditions that would mean that consent would not be given freely. In none of those circumstances can true consent be given. Now, no one can be given it true consent if they are being threatened with violence or of having a knife or another weapon shown at them. And that violence or threat of violence is really interesting, because remember we spoke of the case of PC Mitchell a couple of slides ago. Now, his threat wasn't violence, was it? His threat at that time was, I will take your children away. But that yet still fell in to Section 75. They were happy with that because they said that the threat to take the children away that he would take the children away if she did not have sexual intercourse fell into this, because it was an evidential presumption. It was such a condition in place that almost there was no choice bar her, and true consent was not given. The same as we'll go on as well. We have a look in a little bit about administering substances, or the victim was asleep or unconscious, or threats. So let's move on. Time is going quickly today. From there, well, 76 deals with conclusive presumptions about consent, and this is where a relevant offence has occurred and where a defendant either deceives the victim to the nature of the act, or by inducing someone to consent to an act by impersonating someone known personally to them. So we're going back to that McNally case here now. So starting with deceiving the victim as to the nature of the act. Well, an example of this would be a doctor examining and penetrating the vagina of a patient for their own sexual gratification, and they're doing that under the guise of it being a medical examination. So you're deceiving the victim as to the nature of the act. In this case, the patient believes that they are subject to a medical examination, but actually the doctor is doing it for their own sexual gratification. Now, the second is inducing someone to consent to an act by impersonating someone known personally to them. And again, this is all to do with deception, and we consider that McNally case. But another good example of this is the case of R.V. Devenald, 2008. Now, the defendant, believing the victim to have treated his daughter badly during their relationship, posed online as a young woman, and using this persona, the defendant tricked the victim into masturbating in front of a webcam with the purpose of embarrassing him. Now, the defendant, the father, was convicted of causing sexual activity without consent under Section 4. Now, the defendant argued that it could not be presumed that the victim masturbated without consent, as he knew of the sexual nature of masturbating, and that was his purpose, was for his own sexual gratification. So the defendant essentially arguing that no, it wasn't me, he's masturbating because he wants to receive sexual gratification from it. The Court of Appeal upheld the conviction, outlining that the purpose of the act was more than just the victim getting personal sexual gratification. In this instance, the victim's purpose encompassed sexual gratification of a non-existent woman, when the true purpose was his humiliation. Charlene, yes, from there. So that covers the issues around consent. Not that difficult, as long as you remember the outcomes of key cases from there, and we'll cover that at the end. So moving on to this, shall we try a question out from there? And this about Reginald. Well, Reginald is walking home from work when he sees Chloe, a female unknown to him, unconscious on a park bench. He approaches her and can see that she has passed out through drinking too much. Reginald pulls up Chloe's top and exposes her breasts. He starts masturbating and with his other hand places 2 fingers into the mouth of Chloe. He then leans down and kisses Chloe, putting his tongue into her mouth, and after this he places his fingers into Chloe's vagina. At what point does Reginald commit an offence of assault by penetration? A, when he exposes Chloe's naked breasts. B, when he places his fingers into Chloe's mouth. C, when he puts his tongue into Chloe's mouth. Or D, when he puts his fingers into Chloe's vagina. And just take a few seconds to answer that. Fantastic. Really well done, everybody. It was, the answer was D, when Reginald puts his fingers into Chloe's vagina. We're going to move on to looking at offences now. So a person commits an offence if he intentionally penetrates the vagina or anus of another person with a part of his body or anything else. The penetration is sexual. B, does not consent to the penetration. A, does not reasonably believe that B consents. So for this offence, it only includes the vagina and anus of the victim, not the mouth. And the penetration can be by a part of the offender's body, such as fingers, or another object from there. So a close overlap from there with other offences from there, but it can use either a part of the body or another object. So when it comes to this offence, and this is why I'm saying what I said at the start about, and you've done fantastically, you're really working brilliantly towards your exam now from here. You know this offence, so what's the question they're going to ask you about this offence? If they're going to ask you a question about assault by penetration, it's almost always going to be around some question of this nature about whether the mouth is included, and that is why it's a really good set, this sexual offences, to learn. It's a small area. You can learn the little differences between them, and there's not a huge amount of questions they can ask on that, and you will get those points, and it's really, really good. Right. Fantastic. So let's just have a look at what qualifies as sexual. Now, we had a look at this in our very first webinar, but it's important to revisit it here, because it's defined under Section 78 of the Sexual Offences Act 2003. Penetration, touching, or any other activity is sexual if a reasonable person will consider that A, whatever its circumstances or any person's purpose in relation to it, it's because of its nature sexual, or B, because of its nature it may be sexual, and because of its circumstances or the purpose of any person in relation to it, or both, it is sexual. So we need to break up A and B. Let's have a look at that now. So A, whatever its circumstances or any person's purpose in relation to it, it's because of its nature sexual. So an example would be that masturbation is by its nature sexual and therefore falls in the category of A. So that's straightforward. So because of its nature, it may be sexual, and because of its circumstances or the purpose of any person in relation to it, or both, it is sexual. A person. Let me catch up from again. So B, because of its nature, it may be sexual, and because of its circumstances or the purpose of any person in relation to it, or both, it is sexual. Now, we'll go back to our doctor example that we used before. A person placing a finger into a vagina would be considered sexual by nature. However, if it was undertaken by a doctor for a medical examination, a genuine medical examination or medical reasons, then it would not be considered sexual. And that's the difference. So to summarize, if the activity is not by its nature sexual, nor would a reasonable person perceive it to be sexual, then it will not be for the purpose of the definition. So this in turn would remove a number of really exotic fetishes that a reasonable person would not consider sexual. So let's move on to some sexual assault offences now, because we've got a lot to go through. So first of all, we had a look at assault by penetration that we looked at in detail. From that, we all got the question right, that the mouth wasn't included. So we'll have a look at Section 3, sexual assault. A person A commits an offence if he intentionally touches another person B. The touching is sexual. They do not consent to the touching, and A does not reasonably believe that B consents. And whether a belief is reasonable is to be determined having regard to all of the circumstances, including any steps A has taken to ascertain whether B consents. So the key words here, and I stress this from that, intentionally touches another person. So if that question comes up, that has done before, of somebody on a packed train, emergency stops, or a bus emergency stops, and they fall over, and by accident they, for example, grab the breasts of a female standing in front of them, but it's accidental, it does not count. The touching has to be intentional, and it has to be sexual. Now, we've looked at sexual from there, and so let's have a look at touching, which is defined under 79(8). Well, touching includes with any part of the body, with anything else, and through anything, and of course includes touching amounting to penetration. So the part of the body being touched does not need to be a sexual organ, and it also includes the touching of clothing, as can be seen in the case of RVH 2005. Now, in this case, the defendant propositioned the victim sexually and attempted to pull her towards him and place a hand over her mouth by grabbing at the pocket of her tracksuit. The defendant was convicted of sexual assault contrary to Section 3. Now, the defendant argued that touching a victim's clothing did not count as touching the victim, and argued that a reasonable person would consider the touching as sexual. Well, the conviction was upheld. The Court of Appeal believed that Parliament did not intend to exclude touching a person's clothing from the definition of sexual assault, given the broad definition. And the Court of Appeal defined the test for determining whether touching is sexual in cases where touching is not inherently sexual by asking two questions. One, does the jury consider that the touching could be sexual? And if so, in all the circumstances of the case, does the jury consider that the purpose of the touching was sexual? So was it sexual in the meaning of the Act? Well, whilst the judge's discretions in the present case have not been entirely adequate, he had not adopted a two-stage approach, and the jury had been entitled to conclude that the touching was sexual. The convictions were therefore safe. The grabbing of the pocket was covered under sexual touching, and this had implications for other cases. Another key piece of case law was R versus Bonecla, and this is where the defendant, whilst in a nightclub, removed his penis and ejaculated onto a woman's dress without her knowledge, whilst pressed up close against her. So even though it was the clothing or above or even the ejaculate that had hit her from that, this is still included when it comes to sexual touching. So we'll now have a look at the offence of causing sexual activity without consent, which we briefly touched on when looking at 76, when the father deceived the ex-boyfriend in relation to the daughter, to being the female and getting him to masturbate on camera. Well, the wording is a person commits an offence if he intentionally causes another person to engage in activity, the activity is sexual, and B does not consent to engage in activity, and A does not reasonably believe that B consents. That's a fairly straightforward offence, really, this one. It's committed in a number of ways, and it can be include a woman forcing a man to penetrate her without consent, or even causing someone to act as a prostitute. But some activity must take place for the offence to occur. So just going on, having a real quick recap, because I'm mindful that time is getting on here. So we've got rape section 1, intentionally penetrates the vagina, anus or mouth where a penis is used. We know that penetration is from entry to withdrawal and there's no requirement for ejaculation. Now that's not to say, obviously, in case of sexual offences, when you investigate them, of course.
Take a picture of this, please. Where's your phone?
Or can I just ask someone to put themselves on silent if they would? Thank you, Harry, for doing that. Just going through from that now. Sorry, just going back to what I was saying from there. It's not necessary for rape to prove ejaculation, but of course, when we come to working on real cases, it can make a difference. It's a huge piece of evidence from there, which is why we go through scenes of crime examinations from there. So assault by penetration we looked includes penetrates vagina or anus. Penetration is sexual. Mouth is not included. The penetration we know must be sexual. Touching section 3 we've just gone through from that. We've had a look. We know to take the outcomes from that it includes clothing, and we also know the example of ejaculating on somebody from that or dancing to them also qualifies. And finally, causing sexual activity without consent covers from that. I don't like that wording, actually. Covers fine. I don't like from that. Let's work it on the basis of a woman forcing a man to penetrate her does not consent from that. Right. Okay. Let's have a look at sexual offences against children from there. Now, this is an emotive area from there. We'll go through it now, and we'll start with a question. Stuart, 18 years old, is a paedophile and enjoys masturbating in public. Stuart decides he'll masturbate in an area where he can be seen by the school children on the bus as they go to school. Stuart hides behind a tree and takes his trousers off. Stuart hears the bus and emerges from behind the tree and masturbates. The school bus drives along the road, but the children, aged 14, are busy watching a fight on the bus, and none of them witness Stuart masturbating. Considering the offence of sexual activity in the presence of a child is governed under section 11, which of the following statements is correct? A, as no child has witnessed Stuart masturbating, the offence is not complete. B, the offence is complete, it's not necessary that a child was aware or witnessed Stuart masturbating. C, this offence has not been committed as the children are all over 14. Other offences have been committed though. Or D, the offence is completed regardless of whether Stuart's actions were intentional or reckless. So we'll just take a few seconds to answer that. So we've got a few A's there, we've got a few B's there. Let's have a look at the answer. Well, the answer is B. The offence is complete. It's not necessary that a child was aware or witnessed Stuart masturbating. And let's work out how we got this answer. A person aged 18 or over, now we spoke about ages, the importance, commits an offence if they intentionally engage in activity. The activity is sexual for the purpose of obtaining sexual gratification. He engages in it. When another person is present or is in a place from which A can be observed, and knowing or believing that B is aware, and the important part for the answer B, or intending that B should be aware that he is engaging in it. So it's the intention of Stuart in this scenario that he is witnessed by children on that bus. The fact they're watching a fight doesn't matter. He is in a place where he can be seen. The fact, though, they're watching the fight instead of him doesn't mean he hasn't committed that offence. He is intending that they are aware of it from there. And that B is under 16 and A does not reasonably believe that B is 16 or over, or B is under 13. So note the age of the offender. I cannot stress this enough. Don't throw away marks. The offender for this offence must be 18 or over. Always have a look at those questions from there. To make sure you're not missing out by missing that age from there. And we'll cover ages shortly. Well, this offence is brought in for exactly our circumstances, but can also be committed over a video call or internet chat room. Right, we've still got a lot to go through, so we're going to have a look. So let's have a look at ages now. So we covered this in the first webinar, and I want you to, I want to have a look at it from here now. And don't forget, we'll upload this. You can use this. So sections 9 to 12 all have the same age range of the offender, 18 or over, and the victim under 16 or under 13. So why do we have two ages here? Well, to answer this, we need to look at the gold box on the screen titled Less to Prove. Now, if the victim is between 13 and 16, then the prosecution need to show that the defendant did not reasonably believe that they were 16 or over. This, however, this need to show does not exist for a victim who is under 13, as it's accepted that the offender would have known. This means for the offence under section 10, if the victim was 11 years old, all that the prosecution would have to show is that the offender is over 18 and they intentionally caused or incited the victim to engage in activity that was sexual, and the victim was under 13. Then we can see other variations for section 14, arranging or facilitating the commission of a child sex offence. The offender can be any age and the victim under 16. And for offences under 15 and 15A, that's child grooming and sexual communication with a child, then the relevant ages are offender 18 or over and the victim under 16. Well, as you can see, a number of the child offences we've looked at can only be committed by an offender over the age of 18. So what happens in the circumstances where the offender is younger than this? Well, this is covered by section 13 of the Sexual Offences Act 2003, which means if they commit an offence under section 9 to 12, then they are liable under section 13, which affects sentencing from there. And that means on conviction and indictment, imprisonment to a term not exceeding 5 years, and on summary conviction to a term of imprisonment not exceeding 6 months or a fine. So let's have a look now at some offences around children. Sexual activity with a child, section 9. A person aged 18 or over commits an offence if he intentionally touches another person. The touching is sexual and they're under 16, does not believe that they're 16 or over, or B is under 13. Whenever you see that word intentional, always make a note of it from there. Intentionally touches the victim sexually. Section 10 deals with causing or inciting a child to engage in sexual activity. A person aged 18 or over commits an offence if he intentionally causes or incites another person to engage in activity. The activity is sexual, and either B is under 16, they don't believe they're 16 or over, or B is under 13. Well, remember, this is an offence of incitement. So section 10 is an offence of incitement, meaning that the full offence does not need to be carried out. An example of section 10 would be causing a child to expose their genitalia deliberately for the offender's own enjoyment. Section 11 deals with engaging in sexual activity in the presence of a child. A person aged 18 or over commits an offence if they intentionally engage in activity. The activity is sexual and it's for the purpose of obtaining sexual gratification. He engages in it when another person is present or is in a place where they can be observed, and knowing or believing that B is aware or intending that B should be aware that they are engaging in it. We know, going back to those ages from that, and we covered that under our question with Reginald. He's done everything he can. The fact that he hasn't been seen is not doesn't affect the offence. And finally, causing a child to watch a sex act, section 12, 18 or over, and commits an offence if, for the purpose of obtaining sexual gratification, he intentionally causes another person to watch a third person engaging in activity, or to look at an image of a person engaging in an activity. The activity is sexual, and of course, under 16, does not believe they're 16 or over or under 13. And this offence is aimed at showing children a third person engaging in sexual activity, so it could include the showing of a pornography film or magazine. So what about moving on to 3 other offences we're going to touch on now? Arranging or facilitating the commission of a child sex offence. Well, an offence is committed if he intentionally arranges or facilitates something that he intends to do, intends another person to do, or believes that another person will do in any part of the world, and doing it will involve the commission of an offence under sections 5 to 13. So much information in that definition. Well, the offence can occur in any part of the world. So for an offence under section 14, an example would be making arrangements with a person in the UK to have sex with a child in Vietnam when they go there in a few weeks. And again, there's no requirement for the sexual offence to be carried out. And it's those wording of those offence from there. You've got it all in there. Once you learn these: intentionally, arranges, facilitates, intends to do, intends another person to do. It's all in there in another part of the world, and you can work out your answer from there. Now, Part 2 of the Act excludes those, however, acting on behalf of the child's protection. And this means protecting the child from sexually transmitted infection, protecting the physical safety of the child, preventing the child from becoming pregnant, or promoting the child's emotional well-being by the giving of advice. So why have we put this in there? Well, imagine the scenario of a 14-year-old who has gone to a health worker, or they're working with this 14-year-old, and she is openly stating that she is sexually active and will not stop, or he is sexually active and they are not looking to stop. Well, that allows the health worker to give them advice, to perhaps give them protection, to try and stop them either from pregnancy or sexually transmitted diseases. Meeting a child following sexual grooming, section 15. This is committed by a person over 18 who has met or communicated with another person on one or more occasions, and they intentionally meet the child, or travels or arranges to meet the child in any part of the world with an intention to commit a relevant offence, and the child is under 16. Ages. How many questions have I seen when that child or the person, the victim, is 17 on there? Ages. We've got it on here. You've got that slide. So an example of this is a football coach who's speaking on the telephone to a young boy about football and playing for his team, but his ultimate intention is having sex with that child, or raping that child. So for exam purposes, always remember, for this offence, there's no need for the previous conversation to be of a sexual nature, and indeed it often isn't from that, only that the intention of the offender is to commit a relevant sexual offence. And this offence is triggered as soon as arrangements are made or movement is made by either the victim or offender to meet. And finally, sexual communication with a child. A person aged 18 or over, for the purpose of obtaining sexual gratification, intentionally communicates with another person. The communication is sexual or is intended to encourage, B, to make, whether to A or to another, a communication that is sexual. So in simple terms, sending sexually explicit texts to a 12-year-old child with the intention of sexual gratification from them. Right, we'll hurry along now and do another question. You're doing fantastically, everyone. So Harris is in his house when he hears something posted through his letterbox. Harris collects up to 4 Polaroid photographs of Gary, 14 years old, who is naked. For the purpose of this, the images are indecent. Harris has had antisocial behaviour issues with Gary and his friends previously, and believes that this is a prank. He places the Polaroids into the letter rack. 7 months later, Harris's flat is raided by police for an unrelated matter, and the Polaroids discovered in the letter rack. Harris explains that he forgot that they were in the letter rack and certainly has not shown or distributed them to anyone. So considering section 160 of the Criminal Justice Act 1988, which of the following statements is correct? A, the offence is not committed as the offence relates to children 13 years and under. B, the offence is not committed as Harris has not shown or distributed the photographs, nor has the intention to do so. C, the offence is committed as Harris is in possession of indecent photographs, he has no defence. Or D, the offence is committed as Harris is in possession of indecent photographs, but has a defence as the photographs were sent to him, that should be, without any prior request made by him. Lots of C's coming up. Lots of C's from there. Got a D in there. So let's have a look at our answer. Oh, you lot are fantastic, aren't you? Well, the answer is indeed C. The offence is committed as Harry is in possession of indecent photographs. He has no defence. So why doesn't he? Well, Section 160 outlines it's an offence to possess an indecent photograph or pseudo-photograph of a child in their possession. There is, however, defence if Harris can prove that either he had a legitimate reason for having the photograph in his possession, or that he had not seen the photograph and did not know nor had any cause to suspect it was indecent, or thirdly, that the photograph was sent to him without any prior request made by him or on his behalf, and that he did not keep it for an unreasonable amount of time. So clearly Harris would rely on the third part of the defence in that the photograph was sent to him without any prior request made by him or on his behalf. However, this would fail as he's clearly kept it for an unreasonable amount of time, and that being 7 months. So just breaking down those defences quickly, a legitimate reason for having an indecent photo or something could be for educational purposes or some sort of teaching purposes in either a legal profession or something. It would be very carefully governed from there. And of course, if you haven't seen the photograph and didn't know what it is pretty obvious from there. So just have a quick glance at this topic from here. So indecent images of children, the taking, possession and distribution of indecent images of children are, of course, very serious offences. And Section 7 of the Protection of Children Act covers in depth the definition of a photograph, including negatives, video recording and images manipulated on the internet. For the offence of indecent photographs, it includes downloading images from the internet that will count as making a photograph. If a defendant has knowledge that images will likely be accessed by others, anything downloaded will be considered as downloaded with a view to distribute. An image made up of two photographs taped together depicting an adult woman's naked body with a child's face taped on it will not be a pseudo photograph, but it could if photocopied. Oh, interesting. So what is classed as unreasonable amount of time? Well, what we've learned from cases, an unreasonable amount of time is the basis, previously has been 6 months from that. So I went one after. Now, testing it in law, obviously going through the court, it would be subjective. But I think on the basis that we can use from other offences around there, an unreasonable amount of time would qualify as 7 months from there. You've had an opportunity of it. Now, of course, the smaller the amount of time, and reminding ourselves, remember of this when we talked about when we went through drugs and the defence is that if you were to find drugs on there to get it to an officer, again, we work out from there the time that you get it to that officer or keep it in your possession. The further that goes from there, then of course becomes more unreasonable. And it's quite right, it has to be tested in court from there, but I'm pretty sure that keeping something like images for 7 months when a raid happened from there would be considered an unreasonable amount of time. Right, so going back to that, as I say, we'll cover that from there. Bear with me from that. Right, distributing includes an offer to lend images, and there is an offence where you can show the child was 16 or over, and the photographs only show the defendant and child, and at the time they were married in a civil partnership or living together as partners. So what about, hold on, abuse of position of trust? Done. Right, a person aged 18 or over commits an offence if he intentionally sexually touches a person with whom he's in a position of trust and who are under 18 years of age. A position of trust includes a variety of positions, predominantly around looking after children's accommodation, medical or educational facilities. So perhaps an example would be a child who attends a Sunday school to learn more about the faith and is under the care of the Sunday school teacher, and that teacher abuses their position and commits a sexual offence. Well, that teacher is aware that they're in a position of trust, and it should be taken that they knew or could have reasonably been expected to know that they were in a position of trust. Now, there is a defence, so the defendant must prove that they were married at the time and that the child was 16 or over. And the second part of the defence, if immediately before the position of trust arose, the defendant can prove that a lawful sexual relationship existed between them. So, right, briefly, let's have a look. What's the time? 56, 4 minutes. Fantastic. I've got a whole load of topics to cover from here. What I'll say is that if anyone wants to go, leave at 7 o'clock, I'm really sorry. It's mostly going to roll over about 10 minutes. If you're happy, I don't want to rush through it. I'll just go through the last 10 minutes because you've got a couple more questions. Please, you're more than welcome to stay. I apologise for eating into your time from here. But let's have a look at this. So we'll briefly cover this around exploitation. So paying for the sexual services of a child is governed under section 47, and this means intentionally obtaining for himself or another the sexual services of a child. And this is when you reasonably believe they're under 18. Now, payment for this offence, you can look at section 47, can include a discharge of debt or the provision of services. An example I've given under section 47 is a drug dealer who's offering cannabis at half price in exchange for oral sex from a 15-year-old. Sections 48 to 50 is causing or inciting, controlling, arranging or facilitating the sexual exploitation of children. Now 48 deals with inciting or causing intentionally a child to be sexually exploited. 49 is controlling the activities of another person relating to sexual exploitation, and 50 intentionally arranging or facilitating sexual exploitation, and can be anywhere in the world. And this covers the recruitment of a child into prostitution or getting them to pose for indecent photographs that will be sold. Now, unlike adult prostitution, there's no need to show that the recruitment was undertaken for any gain, and it can relate to a single occurrence. Possession of a paedophile manual under section 69 is possession of something that offers advice or guidance in the abuse of children. And of course, there is it's pretty straightforward that it can be in a variety of formats. So it could be in a book, it could even be on a cassette, a CD, a download, something you listen to from there. And there is a defence, a legitimate reason for possession, and had not read it, viewed or listened to the item and did not suspect it had reason to contain such guidance. So you ask, where would those circumstances will be? Well, for example, if somebody had gone to, say, a charity shop and had bought a job lot of 100 cassettes that they believed were blank, and actually they had never listened to them, and in the middle of those were 4 cassettes that was essentially directing how to abuse children, well, you could argue, well, I had no reason to suspect. And information about guests at hotels, 116 of the Antisocial Behaviour, Crime and Policing Act. At least the rank of inspector can serve a notice on the manager if they reasonably believe it's been used for child exploitation. And a constable can receive the information once the inspector has served the notice in person requesting information about guests. Right, let's see if we can cover sexual offences against people with mental disorder. In fact, we are going to cover this from that. They are fairly straightforward, and we spoke about it right at the beginning when it comes to capacity from there of whether they can consent from here. And we've got 4 offences we're going to look at now. Sexual activity with a person with a mental disorder is under section 30. And that is where the person is unable to refuse owing to a mental disorder, and the person is reasonably expected to know this. And unable to refuse means a lack of capacity to choose to agree or unable to communicate their choice. 31 deals with causing or inciting a person with a mental disorder to engage in sexual activity. Again, intentionally commits this offence, and again, that person is unable to refuse owing to a mental disorder, and the offender is reasonably expected to know this. Again, we have that word incitement, and for the incitement element, there is no full offence needed to be made out. And this is where, for example, somebody could cause somebody to have sex with a friend of theirs. Sexual activity in presence of a mentally disordered person is covered under section 32. Intentionally engages in sexual activity to gain sexual gratification where they know they can be observed, knowing or believing or intending a person with a mental disorder who cannot refuse can see them. Now remember, very similar examples we used to Reginald and the children on the bus from that. That we've got that intention for them to see from there, and can also include causing someone to look at an image. And the 36th offence deals with cases where the person has been induced or threatened to stay and watch. And finally, causing a person with a mental disorder to watch a sexual act. From that, again, for the offender to gain sexual gratification, intentionally causes another person with a mental disorder who's unable to refuse to watch, to watch them engage in sexual activity, or a third person, or to look at an image. So deliberately putting on a hardcore pornography film for somebody with a serious mental disorder who is unable to refuse. Very sad circumstances, unfortunately, but fairly straightforward offences. Right, we are getting there. Now we'll have a look at preparatory offences, which covers drink spiking or date rape drugs, as it's an area that is regularly examined on. So this is our last section on here, but actually I've chucked in a couple of questions for you to practice now coming up to it. So let's have a look at our first question, or our sixth question, I think this is. Tim owes a significant drug debt that he owes to Murphy. Murphy runs a county line and is one of the biggest suppliers of cocaine in the region. Tim has failed to pay Murphy what he owes, so Murphy heads to Tim's house, planning to break in and take jewellery to pay for the debt and more. On arrival, Murphy sees Tim's wife Brittany in the garden. He is attracted to her and decides to rape her to get revenge on Tim. He waits for Brittany to return to the house, climbs over the rear garden fence into the back garden, and makes his way to the rear of the house. The patio door is insecure, and so he enters into the lounge, hears a noise upstairs, makes his way up into the bedroom, enters the bedroom, but Brittany there has a shotgun pointing at him, so he flees out of the house. At what stage, if any, does Murphy first commit the offence of trespass with intent to commit a sexual offence? A, when he jumps over the fence into the back garden of the house. B, when he enters through the patio door into the house. C, when he enters the bedroom where Brittany is. Or D, Murphy does not commit the offence in these circumstances. Oh, lots of A's coming up now on the screen. Oh, wonderful. Absolutely wonderful. Brilliant. Well done, Lauren. Well done, Chris, Martin. Really, really fantastic. You have impressed me in all of these sessions. You're really dedicated, really working hard, and you are going to absolutely smash that exam next week or when you sit it from there. Ever so, please. So, yes, of course, the answer is A, when he jumps over the fence into the back garden of the house. And this is under section 63. To remind myself then, a person commits an offence if he's a trespasser on any premises, he intends to commit a relevant sexual offence on the premises, and he knows that or is reckless as to whether he is a trespasser. Well, a person is a trespasser if they are on the premise without the owner's consent, which Murphy definitely is. And interesting to note that the structure includes a tent, vehicle or temporary structure. Now, again, there is no need for the substantive sexual offence to occur. So, most importantly, though, for exam purposes, the defendant must intend to commit the relevant offence on the premises, so where he's trespassing on, not away from it. Again, when you're going through these offences, when you're looking at them, think of it to yourself, ask yourself, if I was writing these questions, what would I ask? What are the areas they can ask from there? And realistically, there aren't that many. And when you start looking at those little differences, you'll be prepared for any question they put to you. Right, let's have a look at one more question. So, Moore goes to a nightclub and speaks with Rosie. Rosie explains in the conversation that she's never drunk alcohol, as she's worried that she wouldn't be in control. She much prefers mocktails. Should be non-alcoholic cocktails. Moore says that he'd like to buy Rosie a mocktail, and she agrees. Moore tells the barman to put a triple shot of vodka in it, which he mixes in. He takes it back and Rosie drinks it, not noticing the vodka. Moore buys Rosie another 2 mocktails and continues to get the barman to put vodka in them. His intention to get Rosie drunk and then get her to perform a sexual act on him. Rosie, however, starts to feel sick and calls her sister to collect her, which she does. So, considering the offence of section 61, administering a substance with intent, which of the following statements is correct? And the answers are A, the offence is not committed as no sexual act has taken place. B, the offence is committed as Moore intended to get Rosie drunk and perform a sexual act on him. C, the offence is not committed as alcohol is not a substance under 61. And D, the offence is committed regardless of the spiking of the drink as Moore has the intention to commit a sexual act. So just take a few seconds to answer that question. On with B, look fantastic. Stephanie, well done. Amy, really, really good. Tom, oh, Nothing else, only B's. Absolutely correct. The offence is committed as more intended to get Rosie drunk and perform a sexual act on him. A person commits an offence if he intentionally administers a substance to or causes a substance to be taken by another person, knowing that B does not consent and with the intention of stupefying or overpowering B so as to enable any person to engage in a sexual activity that involves B. And the key points, well, this offence includes spiking with alcohol, as we had in our question, when the person is unaware they are drinking. Now, the substance can be injected, it could be applied through a cloth like chloroform, something like that, and the intended sexual activity can be for another person. So let's just cover the alcohol section very quickly, because we've got to be a little bit careful here with the administering of a substance. Now, you all understand it was B. Why? Because I think it was Rosie, didn't we say from that? Rosie was not drinking any alcohol. So he is using that alcohol to spike her drink. If Rosie, however, was drinking, say, single gin and tonics or single vodka and oranges, and each time he was going to the bar, and in fact, Moore was buying her triple instead of single, that is not included for that. So the case that it's included here is because Rosie was not drinking alcohol and he's using that substance and he's got the intention of covering out. Guys, absolutely fantastic you've done so far. And you know, you're running through these questions, but it's demonstrating you're retaining that knowledge. You really are prepped well. Really fantastic. So let's just have a quick reminder of the offences that we've just looked at from here. There's one others in the middle from there. So section 61, we've just looked at administering a substance with intent. That intentional, again, now we know it's aimed at date rape drugs, but also covers any other substance to stupefy, can be for any person. That's a point actually I haven't covered from there. So it means that the offender could be getting Rosie drunk with the intention of his friend committing a sexual offence against her. So it doesn't just need the person giving the drinks, it can be for a third person. And section 62 is committing a criminal offence with intent to commit a sexual offence. Well, that's where a person commits any offence with the intention of committing a relevant sexual offence. And that almost means almost all sexual offences, but not those under the Protection of Children Act. And finally, just coming from that, trespass with intent to commit a sexual offence. We looked at our first question at the moment from there, where Murphy jumped over the fence and landed on the back garden. The question to be asked there, or the sort of area we could be questioned on that, is the defendant must intend to commit the relevant offence on the premises that they are trespassing on. So I think we covered quite a lot there in sexual offences. So I hope it's been useful. You've been absolutely fantastic as always from there, from today. The way you're answering these questions, you know, don't take it for granted that it means you're putting the work in, you know, and you've only got to sit these exams once. You've got it from there. And, you know, this final week, pick it up. We've really, you know, you've really worked at it from there. Shum, you said, can this session be sent to us? Yes, I think I'm going to speak to Harry about uploading all of those, all of our webinars so far that we can go through. We've covered so much so far. But as I say, sexual offences is a really, really key area. You can get some great points on that for the exam. And it's a relatively small subject and covers a lot from there. We'll sort it out shortly. I'll speak to Harry when he comes on here. So we're doing 2 this week, aren't we? We're doing 2. Oh, that's right. Yes, because this presentation was fantastic. I managed to put this next week after exam, and then a very nice gentleman said to me it would help if we have it before the exam, and yeah, that does help from there. So we've got 2. So Wednesday, we've got property offences. That's the last ones. We've done it in a little bit of different order there, but we're going to work through an hour and 5-10 minutes on Wednesday with property offences. That's really good. We'll try and cover as much as we can. We looked at a little bit of burglary, didn't we, on there, but we'll really start drilling in to a lot of property offences from there. Please register. We've only got a few days left. You're going to do really well from there. If you've got any questions, info@policeprovision.com. I will, of course, answer your questions. Lovely talking to everyone that's done here now. How close is it? It seems like just yesterday that we were doing our first session from there, and you're now coming up to your 5th hour with me. I apologise for that. You've all been absolutely lovely. Guys, have a lovely night. Email me if you've got any questions from there. We'll do it all again on Wednesday. I hope you can join me. Anyone else that hasn't been, tell them, come and join us. Let's get that property thing from there. And any other subjects or anything that you're not sure of, just drop me an email. All right, everyone. Listen, what we need to do, we need to get top marks. And the only thing I'm going to ask you after Wednesday's session is I want you to email me and let me know you all passed and how well you did. And you are going to do really, really well and become great detectives, sergeants, and inspectors. Absolutely fantastic, guys. You've been have a lovely night. Sorry for keeping you 10 minutes too long, and I'll speak to you all on Wednesday. Bye bye.